President.
The senator from Alaska.
Mr. President, first I want to thank my colleague from Nevada for bringing up this very important issue. Those of us that are strong supporters of the Second Amendment right are clearly looking at this issue, and I appreciate his leadership on it. Mr. President, earlier this morning, the senator from Arizona had raised a constitutional point of order as it relates to the bill before us, to S-160. And I have to admit, I kind of took a step back and said, well, a constitutional point of order, I'm not sure that I'm familiar with that. So we go to Riddick's, which is our Senate procedure guidelines here in the Senate, and looked up the constitutional point of order and kind of some of the history there. And I was surprised to find that when Riddick speaks to a constitutional point of order, the debate that they bring up was the debate that was held during the consideration of the Alaska statehood bill. And I have had an opportunity on the floor throughout this past year to remind all of my colleagues that this year is the 50th anniversary of Alaska's statehood, and kind of some of the debate that took place on the floor here of the Senate and the process that we as a state took to gain statehood. So I pulled up the congressional record from this debate on the constitutional point of order. Really quite interesting, quite fascinating from Alaska's perspective, because the point of order that was being discussed was whether or not Section 10 violated the constitutional requirements for equality of states and equal footing, the requirement that states come into the Union on equal footing. And the argument that was made at the time was that half of Alaska's territory would be withdrawn, depriving the proposed state of Alaska at the time of the power to have a uniform system of taxation. And I have to tell you, Mr. President, it just kind of takes you back to where we are with the D.C. Voting rights issue that we have before the Senate some 50 years later. So I kind of put that in context as to why I have taken such great interest in where we are with the debate here in D.C. and representation. In Alaska, there's a huge fight as to whether or not we should become a state. My grandparents on both sides were involved in the debate at the time. It was a fight to gain control of our resources. It was a fight to basically keep those who had control of the fish down in Washington State and the Pacific Northwest, kind of keep them out of our backyard there. But it was a fight that has kind of been relived or rejuvenated or certainly discussed in local news in this past year. And it brings up the issues that were so key at the time, why it was so important for the people of Alaska to have representation in Washington, D.C. So I appreciate the pleas of the people of the District of Columbia, the residents of this very small area, for debate, for consideration of representation within the Congress, because it was just not too long that those same cries were being heard back in Alaska. You've got to give them credit for a pretty effective lobbying campaign. I don't know of any other state that has used their license plates to gain the attention of the rest of the country in terms of what it is that they're asking for. No taxation without representation. But Alaska is a different scenario than what we have here in Washington, D.C. Alaska, 50 years ago, was a territory. The District of Columbia is a different entity created through our Constitution and through amendments to our Constitution. The District of Columbia isn't able to petition to become a state like Alaska tried or Hawaii tried just shortly after us, or what Puerto Rico is currently going through. Our Constitution makes it clear that they are not a state. But I supported cloture yesterday because I felt it was important that we have this debate here on the floors of the Senate, that we hear the perspectives that are being presented, whether it's from the senator from Connecticut or the senator from Arizona, both senators from Arizona, and to allow this issue, which is so important to some 600,000 people, that we give them this debate. I represent a state of just a little over 600,000. I can only imagine. It was back in 1960, June 17th, that the Congress approved and sent to the states for ratification the 23rd Amendment. It was the 23rd Amendment that extended to the people of the District of Columbia representation in the Electoral College. And it was 285 days later that the 23rd Amendment was ratified by the states. And that ratification settled the question of whether the people of the District of Columbia should have the right to vote for president. And it settled that question absolutely conclusively by way of amendment to our U.S. Constitution. Now, I believe, Mr. President, that the people of the District of Columbia have been without representation in the United States Congress for too long. I have strongly supported the view that the people of the district should have voting representation in the House of Representatives. But what we have before us today, S-160, does not conclusively resolve the question of whether they will. The question of whether Congress may, by legislation, grant the District of Columbia a vote in the House of Representatives, we know has been a matter of spirited debate, not only here on this floor, constitutional scholars on all sides of the issue. It was our Assistant Majority Leader yesterday who observed that the approach that has been taken with S-160 has attracted, I think the word that he used was some strange bedfellows amongst the community of constitutional scholars. You have individuals, very distinguished individuals such as Ken Starr, Viet Dinh, who suggest that, in fact, S-160 is constitutional. On the other side, you have extremely well-respected gentleman, Jonathan Turley, who's testified that despite the best of motivations, that S-160 is fundamentally flawed on a constitutional level. It would only serve to deny or to delay true reform for district residents. And his conclusion is that this legislation is facially unconstitutional. You've also got review, our nonpartisan Congressional Research Service did their assessment, their analysis, and they too cast doubt on the constitutionality of S-160. Their report, and this was back, well, it's just this February 17th of 2009, they state that although not beyond question, it would appear likely that Congress does not have the authority to grant voting representation in the House of Representatives to the District of Columbia. So the key point here, Mr. President, is this. I believe that the District of Columbia deserves representation in the House of Representatives, but S-160 does not conclusively resolve the question of whether they'll get it. I think we've heard on this floor that where this is going to lead is litigation, first in the United States District Court and then subsequently to the U.S. Supreme Court. The issue, of course, is how do we interpret Article 1, Section 2 of the Constitution that says the House of Representatives shall be composed of members chosen by the people of the several states. I don't think there's any dispute amongst the constitutional scholars that are out there that the District of Columbia is not a state for the purposes of Article 1, Section 2. And if the courts shall conclude that Article 1, Section 2 of the Constitution means what it says, that only the people of the several states can send representatives to the House, then basically we start all over. We start all over. We start anew with a constitutional amendment on DC representation. So, Mr. President, I would suggest to the body that what we are engaging in today is almost a cruel hoax, because what we're doing is we're delaying the end of taxation without representation for several more years. What we're getting is getting into the courts. Is that what the people of the district are really seeking? I think 49 years ago, the Congress understood what we needed to do in order to provide for clarity and to conclusively resolve the issue with the District of Columbia. With the 23rd Amendment, we knew that the way to handle it was to give the people of the District of Columbia a voice in the selection of the president and vice president, and the route that they chose to take was the route of a constitutional amendment. They knew then that that was the proper route to take, and I would suggest that that today is the proper route to take to provide for this. This senator believes that it is what we owe to the people of the District of Columbia to get it right the first time. Let's resolve this. A constitutional amendment passed by the Congress, ratified by the states, settles the matter of DC voting rights conclusively, and S-160 doesn't. Now, we know the history on this. This was tried once before. This was back in the late 70s. It was adopted by 2/3 of both bodies and sent to the states for ratification. Unfortunately, only 16 states chose to ratify, and within that 7-year period, so we basically come back to start over. But, Mr. President, I would suggest to you that that is the method and manner we need to approach as we try to provide for representation for the some 600,000 people who are residents of the District of Columbia. I am prepared to support a constitutional amendment and to work for its ratification, and I intend to introduce that constitutional amendment today. It will not be part of S-160. A constitutional amendment is a different process, one that is done through joint resolution as opposed to a Senate measure or a House measure. But I believe that amending our Constitution will provide justice for the people of the District of Columbia, and I look forward to working towards that end. And with that, Mr. President, I yield the floor.